this case. So I want to know if the parties in the case have any issues, procedural issues that need to be discussed.
Well, what I was told by the staff at the PSC, and I documented the transcript for you guys to see, and they did tell me that just filing a formal complaint gives them a right to make me the primary plaintiff in a state regulatory investigation, and that's not accurate.
Well, that is in fact accurate. You filed the complaint, so you are the complainant. You don't have to be an attorney to be a complainant. Next issue?
My next issue is well, I don't think we addressed it. Did you address it? Maybe I didn't hear you, but nobody asked me.
No one asked you if you were a lawyer?
No one asked me if I wanted to be the primary plaintiff.
Well, you filed the complaint. That makes you the primary complainant.
No, that just makes me somebody with a complaint. I'm a customer.
You are a complainant and a customer. The person who files the complaint is the complainant, no matter who they are.
But I can't, as far as I'm aware, I can't be compelled to do legal work.
You can't be compelled to do anything. You're here as a volunteer.
No, I'm actually here because of these systemic issues. When I couldn't get anybody to document anything in writing and close our resolution, I found more and more issues along the way. In the PSC handbook, the help for the EFIS, it shows attorneys have access to automatic notifications for every.
So do you, Mr. Miller. As I said, I did address this issue in the first things that I said. Everyone has the same access to EFIS. You all have professional accounts. So you have the same notification that everyone else does in the case.
Well, that's not true with regard to data request responses. And that's my concern, is that I didn't know for 3 weeks that the defendant had given their responses through the EFIS system. And I'd also like, if you wouldn't mind, correct me if I'm wrong, but we are held to the same standard in these proceedings as federal law with regard to all discoveries being legal filings and all attorneys and parties having a right to equal and fair access to all those discoveries at the same time.
Okay, Mr. Miller. I also addressed those issues in my preliminary statement to you. The data requests go from the party who asked for them to the party who they are coming from.
Yes.
We are a state agency, and although we are bound by the Constitution, we do not decide constitutional issues. We determine cases on the basis of regulations and state law. So that answers those questions.
Well, it doesn't. I'm asking you directly if your proceedings have to comply with federal constitutional law, even though under the section where you guys get to make your own laws and rules for your own way of doing business. I'm asking you if they have to comply with federal law at the state level.
If you're asking me if the Constitution is the overarching legal document for the United States and for us, that's true. But the procedures that determine what happens at the Commission are the rules and regulations and state statutes, as well as the policies and procedures of the Commission made by the Commission. I'm giving you the same answer. I understand you may not like it,
but
that's the way it works.
It's just a yes or no answer. Are they compliant with federal law? Because, and do you recognize they have to be compliant with federal law, even though they are different? What you're telling me is you do things differently, and you understand that it's different outside the federal law.
Okay, now, Mr. Miller, we're sort of veering into you asking me for legal advice, and I don't give legal advice.
Okay.
So, next issue?
I have several issues. Do you mind looking at any of our data requests, or does that have anything to do with anything? I've got a lot of questions I've already posed to PSC about these issues through data requests.
This procedural conference is not to determine the data requests, and I don't look at data requests. If you have problems with the data, you are welcome to address those issues as you can bring those issues to a hearing if you have a hearing, and at that time I will rule on whatever issues there are.
I appreciate that. Other issues are?
Absolutely.
Okay, thank you. My other issue was obviously a breach in the investigation. There's some ethical, legal, and so what I'm curious is, it's my understanding I have a right and a duty as to bring constitutional issues to your attention if I find them during these proceedings. And so I know you said that, but I want to make sure that it's not something that the regulatory oversight and the court finds necessary for discrepancies and things like that. If we find these types of constitutional issues, are you suggesting that we shouldn't bring them up to the judge?
I'm not just suggesting it. I'm saying that this is not the forum for deciding constitutional issues. The Public Service Commission is an administrative body, and we don't decide constitutional issues. In terms of the data breach, I said in my preliminary remarks that I'm asking everyone not to file pleadings that have the names of people, ordinary citizens who are not parties to this case. You are breaching their confidentiality, and I understand you are concerned about these breaches, and I hope that you will stop posting people's names and stop the breaches.
Well, I have permission from the individuals to use whatever information I need to for this legal proceeding, the breached couple.
Well, and you're welcome to bring those people to the commission when and if a hearing happens. You are not welcome to post their names and addresses and information about them in EFIS.
Understood.
So disseminated to the world.
Yeah, absolutely. And I just wanted to say,
they have a right to privacy.
Yes, I just wanted to add the EFIS filing. I was counting on they have their own methodology and system in place for if there's confidential information posted, that it creates two copies, one public and one confidential. And so that was my mistake. I just want to add for the record, but I also wanted to clarify, if it's public information, then we're not obligated to confidentiality.
That's quite true. If you file the pleading from another case in the Public Service Commission, it's public information. But people's names and addresses who are not parties and are not represented, and you're not representing, you don't have permission to file those. And my understanding is that you're not an attorney and you're not representing anyone else in this case.
Correct.
Is that correct?
I'm actually representing the people. The public interest, which is what the PSC should be doing.
You can represent yourself, but you can't represent anyone else if you're not an attorney in front of the Public Service Commission.
Okay. And then, so we have to deal with the issues of the breach itself with regard to discovery. So I think
we have dealt with one of the issues of the breach, and that is that I have taken some of that information off EFIS and redacted the names of all of the people that have been disclosed.
Right, and by doing that, you reordered all the numbers of my filings, so all my notes and everything are just completely they're scrambled up, because what was filing number 106 is now filing 46, and so my notes and all my.
That's quite true.
But that's not how it's supposed to be. There should be an issue in the system where when the filing is recalled and a legal attorney's building this case, that the system doesn't screw up the order of the numbers.
Actually, you can blame me for that. When the filings are taken out of EFIS, if any judge takes them out, then they get renumbered. And there's still all of the filings that you filed, you can still access them by the date that you filed them and the time that you filed them.
But you didn't acknowledge how it mixes up the numbers and screws up my notes for my legal proceedings.
Well, I'll acknowledge that now. I apologize to you if you're confused. That's how the system works.
So you're saying the system is not set up to actually keep the file numbered with the file, even if files are removed, or you're saying that in the event that a judge does it, that it screws it up?
Well, I'm saying that those filings were removed in this case, and the filings are renumbered, but they are still accessible by date and by time.
Gotcha. That part I'm aware of. I appreciate it. My other issue is handling of confidential information. You haven't really addressed here public, or I don't know if we're public or private still, but I assumed all of our proceedings were public. All our filings were public, and so if this is private, if you could clarify that, I would appreciate it.
Well, if you're asking me if this phone call is public, it's not public now. The only people that are on it are you all and me, but there will be a transcript that it will be filed in EFIS. Is the entire public going to have access to that? I can't answer that question. I'm not certain.
But you are familiar with the EFIS system?
A little bit.
Okay, so then you can tell me if there's different account tiers and different I know you said we all have the same one, but can I verify that? Can I see all parties' accounts that show?
No, you will not.
Then how can I verify that?
Other parties' accounts are confidential, and confidential in terms of I'm not giving you information about the other attorney's accounts, just in the way I would not give them information about your account.
And that's fine. Could you tell me where to go where I would find my own tier? It says I'm unverified. I don't know what that means.
Unverified means...
Now you're unverified. Now we're both unverified.
Welcome to the unverified club. Yeah, that just means your phone number is not, hasn't been entered into the system.
Oh, okay. And so, is there anywhere I can see on my own account?
There is not.
And is there any way I would know, as my own legal representation, what the different benefits are between the different tiers of service? And why wouldn't I be able to see what type of account I have in comparison to other types of accounts?
Yeah, there's no way for you to do that, nor is it necessary or relevant to the issues in this case.
Well, it could be if I think that if the PSC is getting data response notifications for all notifications. It says lawyers get automatic notifications for all filings. It doesn't say what you said, your handbook. So what you're telling me and what your help text for PSC online is telling me two different things.
Okay, Mr. Miller, for the fourth time, everyone has the same designation in this case. You have the exact same designation as the attorneys in this case. You have the same access to information that they do. That answer's not going to change. And that professional designation is pretty much the highest designation that you can get. It gives you the right to file things in EFIS.
Right, and I'm aware of that, but I'm wanting to determine that we are. Do I need to cite it for you to show where all notifications are automatic? If you're a lawyer?
Well, you have the same status as a lawyer, even though you're not one.
Isn't that special?
It really is.
And so, on your help center, when it says all automatic notifications, that includes data request responses. I'm sorry to tell people, but unfortunately, that's the case.
Data request responses are between the parties only, unless and until they become evidence, as I said at the beginning of this phone call.
Okay, so they're not legal filings.
Well,
I'm gonna regret this, but I just want to interject for one moment. So the Commission's EFIS system allows for data requests to be issued from and to the Commission staff through EFIS, but non-staff parties don't have access to the ability, meaning that they have to transmit data requests and responses via email. I don't know that staff has received any data responses in this case. I believe data responses have been issued on Spire. Data requests have been issued on Spire, and I think data responses from Spire would have to come via email. I don't know if that helps to clarify that. I welcome if anybody wants to correct me.
Could you clarify? Are you basically saying that you get that was my original concern, was I was getting notifications for the filings, but when someone responded to it, it's not my job to babysit this. It's not my job to babysit this for emails showing when people file something and when they don't. It's one thing.
Actually, Mr. Miller, it is absolutely your
Well, what I saw was the data request response was sent to the PSC on the 23rd, and I didn't see it because
That's because data requests are sent from the party making the request and the party providing the response.
And
if you didn't make the request, if you're not involved in the response, then you don't see it.
And I think, can you clarify to me, so you're saying on the record that all parties are not legally entitled to all legal filings at the same time?
Yes. The staff will do an investigation, and then they will file a report, and the report will be public after it is filed.
Could you clarify that? I don't know that I understood. What I'm asking is, if someone files a response to a data request, all parties have to be notified at the same time, legally.
The data request responses are between the parties only, the party making the data request and the party providing the response.
Yeah, that's a policy I'm trying to change.
Well, I think, I think that's great, but that's not an issue in this case.
It's an issue in the case. Anything that makes it harder for the citizen to go up against, fighting injustices isn't in the public's best interest.
Well, I think we're getting a little far afield. What we're here to talk about is the complaint that you filed. And the complaint that you filed is you were put on budget billing from Spire.
What Mr. Kleiser was saying, we do get that when Spire gets data requests from the Missouri Public School Commission staff, we do submit those data requests back through EPIS. Those DR responses are accessible by all parties. The notification might not be there. I don't believe the actual notification is actually provided. One of our other cases, I believe the OPC sent staff data requests. We were notified that those data requests were sent to the OPC. We were not notified when those responses were provided by the staff back to the OPC. So that's just how the system is set up. That's just an example of how the system is set up. We were able to access the responses that the staff provided. So
yeah, and real briefly, I have to say, having access and serving to all parties are not the same legal terms. I'm sorry.
Actually, they are.
Okay.
Judge, I would pipe in. This is Mark Johnson. Pursuant to our rules, data requests have a default response time of 20 days. So I would state that upon notice that a data request has been issued, all parties are aware that a response will be provided within 20 days, unless, of course, objected or an additional amount of time is requested.
I want to talk about a little bit. It doesn't seem like the facts in the original complaint are disputed. Mr. Miller, you're saying that you were put on budget billing and you didn't want to be. Spire's admitted that they put you on budget billing and that it was a mistake and that you shouldn't have been, and they took you off of it. I want to know if the parties in this case would be amenable to submitting the case on the facts, because they're not in contention.
Because you put it in layman's terms for me? And
The facts are already in front of me. I can look at the facts and the information that's there and make a decision.
oh, you can. Well, yeah, if you don't consider any procedure, if you don't let me finish all my procedural issues, I'm sure you probably could.
Well, there are no procedural issues in your complaint. The complaint you filed had no procedural issues in it.
Yeah, they did.
Procedural issues that you are raising are ancillary to the complaint that you filed.
But I have every right to.
This is not the forum to deal with those issues.
I
understand that's frustrating. I understand that you're unhappy about that, but that's not the situation that you find yourself in.
Who does the PSC answer to for regulatory compliance with regards to U.S. constitutional law and their proceedings?
Well, as I said in the beginning of this, and a couple of times now, we don't decide issues of constitutional law. But if you get a decision, like if you submit this case on the facts to me and you don't like my decision, then you have an opportunity to file for a rehearing in the commission, and then you have an opportunity to file a case in the Western District Court of Appeals. I mean, my decision has to come first, then the rehearing decision, then the Court
Oh,
of
yeah,
Appeals.
right. I get it.
And they will, at that point, if they believe the case contains constitutional issues that need to be decided, that happens there. That does not happen here. So back to my question, how about submitting the case on the facts?
Are you asking me?
I'm asking everyone who's on this call who's involved in this case.
My response is you can't expect to have a fair and legal hearing if you're not willing to listen to ethical and regulatory proceeding issues.
So you would prefer to, you're not open to mediation or to submitting the case on the facts?
What I'm suggesting is when you screwed up all the filing numbers, Judge, you screwed up my case.
Well, I don't agree with that assessment. I don't think renumbering the things you...
Filing number? That's exactly how. And I would say, you know...
I understand that's confusing. You haven't answered my question. Would you submit the case on the facts?
Only all the facts, not just the ones the PSC wants to, and that Spire want to address.
Okay. Mr. Arias?
I guess my first clarifying question would be, and this is the way Spire answered the complaint as well, would be the facts that we're discussing, submitting the case on would be the facts from the, I don't have the exact date, the July 2nd initial filing opening the case, that's titled formal complaint.
Yes.
That's the document that we answered and are treating as the sole source of the facts in this complaint. Then your answer would, Spire's answer would be yes to submitting it on the facts. We would also, I mean, if that's not the method taken here, the path taken from this conference, we'd also probably be filing for a motion for summary determination.
Okay. Staff counsel, what about you? Are you amenable to the case being submitted on the facts? Or
Staff is amenable to the case being submitted on the facts, correct?
all right.
Could you clarify what you mean by that? Only thing that I filed are facts. Whether you don't like the facts or the identifiable information or not is another story, but they're facts, just for the record.
Well, the facts in the case that have been submitted are the ones that are contained in your formal complaint. I mean, you determine the facts by your formal complaint, so.
Yeah, and I mentioned systemic issues, wherever that rabbit hole leads.
Well, what I'm hearing from you, Mr. Miller, is that you are not amenable to submitting the case on the facts.
I don't know what that means.
It means that I take your formal complaint and the facts in your complaint, and I take the answer from Spire and input from staff counsel, and I look at all of those things from all of those parties, that I look at those facts, apply the law, and issue a decision.
Is that what you want to do?
Without a hearing. I think in this case, this can be decided as a matter of law. You have an absolute right to have a hearing if you want one.
If I think that the PSC will actually plead a case that I can listen to, and to me, it's the PSC's job to do the investigation, not mine. That's where we're screwed up here. And I haven't seen, you know what I mean? All I've seen is one data request out of them, and that's it. That's all I've heard. And I spend countless hours up late nights, being a lawyer, looking stuff up, looking for discrepancies, looking for wins.
Okay, that doesn't really answer my question.
It sounded like you told me that you're not going to listen to all the facts, only the facts in the initial filing, and I just don't think that's fair. I think I have more.
That's not what I told you. I told you I would listen to what's been filed by you, by Spire, and by staff counsel. All of the parties in the case.
and all the facts that have all the facts that have come out because of that initial case.
I would probably make a ruling on some of those issues as well.
Then I'd be willing to have a discussion.
Well, it's not a discussion. What happens is I take all the documents that have been submitted and apply the law and then make a decision.
Judge Walker, may I interject here very quickly? Mr. Miller, he did say that he saw the staff, I think he said staff submitted one DR. Staff has actually submitted 2 batches of DRs, and I'm going to take a quick look here.
Sorry, 2 sets of data requests.
2 sets of data requests.
That's correct. And they also didn't answer mine by the time we had this hearing today.
Well, that doesn't, I think we should just focus on the issue at hand. And
But
issue at hand is, Mr. Miller, are you willing to submit the case on the facts, or are you going to a hearing?
I'm a little concerned that you would even ask that when there's open data requests from a council to council, still on the books.
And you have a perfect right to wait until there are answers to those requests, or there are more requests.
I'm in it for the long haul, Judge.
Okay, that's your right. So what I'm going to do now is I'm going to exit the call and then let the parties. I know that I shouldn't know it, but I do know that there was a settlement offer that was made that had been rejected. So
Twice.
I would like you to discuss whether or not there is any opening for settlement in this case. So I'm going to leave the call and let you all talk to each other.
Judge, thank you.
Your Honor, hold on. Before you go, is there an order, if settlement does not appear to be forthcoming, does the commission want the parties to present a procedural schedule at some point?
Thank you, Mr. Kleiser. Yes.
I didn't hear that.
He's asking if we're going to a hearing, we need a procedural schedule.
Oh, yes.
I mean,
I didn't see one of those either.
We don't have it yet. Why don't you all submit a procedural schedule within the next couple of weeks?
If everybody just owned up to what they did in the first place, we could take a short recess and probably come to a resolution where people, admit.
I'm not taking a recess, Mr. Miller. I'm leaving.
Hey, just real quick, Judge. In the very beginning, at like July 1st, Mr. Kleiser actually had an email with me where he pointed out the systemic issues, and that's what led to the initial complaint leading off into.
This is not for the judge to hear right now.
It's actually already on file.
We're not at a hearing, and you can't object, but he's right. I'm not here to discuss all the facts and issues of the case.
Oh.
I'm here to get you to talk to each other right now. So I'm going to leave. Thank you all for coming and participating.
Well, oh, okay. So,
Mr. Arias, do you have another issue?
No, not an issue. Your Honor, not really quick.
it's nice to meet you.
Thank you.
Are you not getting back on?
No, I haven't left yet because Mr. Arias is trying to speak.
Well, you said you were going to take a recess. It sounded like you were going to get back on the call.
No, I am not.
So when I'm done with these people, I just hang up.
Yes.
Okay, thank you.
Mr. Arias, do you have an issue?
Not an issue, Your Honor. Just once we do file, once we decide whether or not the settlement discussions are going anywhere today, do you want to set, it's like 2 weeks out after staff files its report, or for procedural schedule to be filed? Is that what you're thinking?
Yeah, why don't I issue an order to clarify it? And that way everybody will be on the same page.
Okay, that's fine.
Okay?
One thing I do want to say, and I don't know if this is the proper place to say it, but I think it's somewhat procedural. So staff is conducting an investigation, but it is anticipating that it will need some more time because of DRs. So DR responses are due on the 28th. I think the order states that that the commission needs a response or a status report by the 31st, which would effectively be the 29th. So staff is asking, and we do anticipate, I guess depending on how the talks go after this, we do anticipate that we might need to send out another batch of DRs that we do have ready to be sent out today. So because of that, that might affect any procedural schedule. I just wanted to let everyone know that as well.
That was why I filed for a motion for a continuance, because they sent the first batch of data requests, they responded, and then they didn't like their responses, so they sent another set saying you need to answer these a little more in depth. And for some reason now their response time is going up and up and up. And she's correct. So it sounds like they have another set to go out, but with all these us not having that thing you just mentioned, an outline basically of what the timing is for this case and the procedures and proceedings and all that, how are we supposed to all be on the same page, you know?
Well, I'm hoping to solve that problem for you.
Oh, thank you.
I will issue a procedural schedule. I would encourage staff to ask for the time they need instead of continually asking for continuances. I really am not a fan of getting a continuance, asking for 2 weeks and then getting another one and another one and another one. And I also would note that this is a fairly contained case, so my expectation is that the investigation will be forthcoming soon.
All right, thank you.
Okay, all right. Good afternoon, everyone. Thank you for coming.
Thank you, Judge.
Dad.
Let's see. So are we supposed to talk about something? I don't understand. You guys are lawyers, I'm not.
Yes, so what's happening currently right now is that we've been given an opportunity to discuss if there's a potential way that we could settle this case and resolve the issues in front of us. That's kind of the purpose of this discussion. And I know that it's already been mentioned, but Spire had sort of already put forward at least one settlement proposal in private to you. I don't know if that's a good place to start, or somebody else would like to start somewhere else.
Well, I would just like to start by saying that this has, I feel very compelled to do legal work and investigative work and administrative work and handling breach data work and a multitude of other types of work that and my life has been turned upside down by having to devote almost all my time to this issue that I shouldn't have ever had to have been in the first place. And Spire has already publicly, formally admitted to these things. So that's why the judge was kind of ready to just kind of, you know, put the gavel down. It's pretty close, cut and dry, except I could never get anything in writing from Spire. And then after all this hassle, I do feel compelled to require some compensation for that, in order to have a settlement where we just say, let's just close the whole thing.
One really quick, and I want to bring this up as a general matter, just because without meaning to offend any of the parties, I want to make sure everyone on this call understands that this being a settlement conference is strictly confidential, and that the purpose of this discussion cannot be recorded or shared elsewhere. And to do that would be a violation of the law. I want to make sure that that's a very clear statement that this conversation is strictly confidential.